of various issues and all very interesting ones. So we are going to get started. I am going to give extremely short. I have lost my document in the shuffle. Jimmy? Yes. So I'm going to give extremely short introductions to our panel. Every one of the panelists is very, very expert in this area, and it's really a treat to have them all together on this panel. So I really want to get us to the substance. But if I may quickly, Professor Yannick Radi is a professor of public international law at Louvain and is also on the ICSID panel of arbitrators, has great expertise in public international law, law of treaties, and dispute settlement. Don Imane Hewitt, sorry, right beside me, is at Quinn Emanuel doing international investment treaty and commercial arbitration, and also has a history with Department of Commerce in the US, and again, a huge amount of experience. To my left is Lucinda Lowe, who is at Steptoe and is an expert in international investment arbitration. She is an expert in foreign corrupt practices types of litigation and is also a member of the ICSID panel, having done a number of tribunals and ad hoc committees. So again, fabulous expertise here. We have Sylvia. Yes. All right. Yeah, exactly. Very good. Sylvia Marchilli is at White and Case, and again has done numerous cases at ICSID and other institutions on investor state, and has co-authored one of the leading books on annulment under the ICSID convention. And finally, besides Sylvia, is Lynn Laird, who is at Crow Mooring in their international dispute resolution practice. He's co-head of that group. He is also an extremely experienced counsel and has been doing investor state arbitrations lately as an arbitrator as well. So you have here a host of expertise, including from every perspective you could want on the topic. Now we have a huge number of topics that we want to go through, and we've decided we're going to be quite informal. We're going to be fairly short and make sort of various points and try and make this conversational. And I would very much encourage anyone in the audience as we go along, if you have questions or things to add, please do. We're the last panel of the day, so we can do things a bit differently here. So we're looking at really three basic things. The first topic is going to be expectations of investor state and critiques of investor state. Then we're going to talk about what we call architectural changes, what kinds of systems are around to deal with investment dispute settlement. And finally, procedural change and procedural reform. So let's get started now. We're going to talk about first expectations of investor state. And the big question, what was it intended to do? And has it met its promise? We'll start with Lucinda's thoughts. Thank you very much.
First of all, I want to say thank you to the organizers and to to meet together. So many talented people, Mexico and elsewhere. So it's really great. It's been such a pleasure to reconnect with some old friends. Now I have two. Okay, I'll thank you again. Okay, but on to expectations. Well, our panel was joking earlier that I think I only need one. Yeah. Our panel was joking earlier that Meg really said everything this morning and there's nothing left to say, but I'm going to try. So I identify three goals of the ISDS system, if you can call it that. First is investment promotion. That's widely recognized as a goal. The second and third are interrelated, and in my view, not always quite recognized in the way I'm going to talk about them, but promoting the peaceful resolution of disputes through a depoliticized mechanism. But here's the second part, and this is my third goal. On a rules-based system, not a political system, not a power system, but a rules-based system. And I think that's really important to keep in mind as we evaluate this system and the critiques. On the question of data and whether the system has really promoted investment, I think we all agree it's very hard to know. Some people have tried to do empirical research on this issue, and it's pretty mixed. But I think it's inherently difficult to do. I mean, you have to go back to the 60s, to the first wave of these treaties, and say, what difference did they make? And I think you have to bear in mind when you talk about international, transnational disputes, look at commercial arbitration. I mean, there's always been a desire for an independent, delocalized forum. So I think the data piece is really hard. We could argue about that forever. And I'm going to give up on that because I just think it's impossible. But the second and third, I think, are really important to pause on right now, because we're in a period of rising nationalism, rising authoritarianism, a rising desire in many countries, including my own, the United States, to do things just on the basis of power, to be self-judging. And I think we have to think about what this system has really contributed. It's not a perfect system. We can agree on that. International law has changed tremendously during this period. And so any system would have to grow and adapt to deal with the host of new issues. But I think, to use a US expression, and maybe you used it this morning, we don't want to throw out the baby with the bathwater, as we say, because I think we still need to really focus on the benefits of depoliticized, rules-based system. And that's where I'll leave my initial remarks.
Am I closing out? Yeah. Just to stick to the philosophy of this panel, I will build on the remarks that you just made. First of all, I think a key word is peaceful. Now we have to take into account that we have entered a period where there is a crisis of multilateralism, where there is a growing crisis everywhere. At the same time, we also should take into account that we have a wave of populism across all the continents. And in this respect, I think that policymakers should think twice and even more before taking on board and providing credibility to a urban myth, as you put it this morning, Meg. And I think that in some countries, some policymakers, yes, just take it as granted, those urban legends, without realizing that by doing so, they are fragilizing a system which has been quite successful in providing stability, security. And I think that more than ever in the past decades, we do need stability and security.
Ian?
Yeah,
This will be a logistical challenge.
when I look at this, and we titled this section "Expectations of ISDS and Critiques of ISDS," perhaps the expectations might have been a little too high, in the sense that when we look at the promotion issue, I think the data there, as we talked about earlier, is inconclusive. From the protection point of view, the nature of investments and investments in the international economy really go hand in hand with the trade elements as well. And it's not a single, easily, studied, narrow function of the economy. It's all wrapped up in the overall international economy. So the idea that perhaps ISDS would be some sort of panacea that would, answer all the issues for investors when they have problems when they go and do, invest abroad, I think would have been, overstating kind of what these treaties can deliver. But to the extent that they have been taken up extensively by investors, that it's provided a valve, a release valve for a lot of these disputes, you do have to ask the question, say, over the last 25 years, there's been roughly 1,000 of these cases. What would have happened in the alternative if these mechanisms hadn't been available? And I guess the answer is a lot of rancorous political discourse, a lot of diplomatic time taken up by governments to help to resolve these issues. And that is, in fact, one of the reasons that states take up these international mechanisms, is to provide that kind of neutral mechanism, that dispute resolution mechanism that can resolve these types of issues in a way that doesn't require that kind of high-level political drama. Granted, ISDS isn't devoid of political drama. There is, as we've discussed in other panels, there's some drama. But I think we could probably agree that a great deal of it is being removed out of the system while these tribunals address these, sometimes big issues, sometimes small.
I think we sort of creeped into the next question, but it was for Sylvia and Dawn to look at the idea of whether the expectations were reasonable in the first place. Sylvia.
Thank you. So I'll take the liberty of going back to some of the answers that we just heard. In terms of the expectations on the goal of this system, I would say that it's circumspect, but very important. And going back to the point that Lucinda was making, it's nothing but enforcing the rule of law, or providing a space for the rule of law to be enforced at the international level. And what I think was revolutionary about it was that it gave standing to investors to sue states, right? Investors are not, since we're in the law school here, they're not subjects of international law, right? It's only states and those who are conferred that standing. And as it was the case in the human rights field, where individuals were given that standing at some point, quite rightly so. And by the way, I'm not trying to compare human rights to investment arbitration, but it is revolutionary. It was revolutionary in that sense. But in terms of I'd like to remind myself and remind those around me of how basic those principles and the substance are. And we can discuss, of course, every case, as we could discuss any litigation case in detail, but we're talking about not expropriating without compensation. There's nothing groundbreaking about that, I would put. To act fairly and equitably, even to not lure an investor into investing and then changing the rules of the game. That seems quite intuitively nothing too groundbreaking. Again, it's just enforcing the rule of law at the international level, and especially focusing on those investments that are typically long-term, sunk, and that require that certainty, as we were saying. And as to the expectations in terms of promoting investments, I would make a couple of brief comments there. First of all, we should seek to enforce the rule of law because we should seek to enforce the rule of law. Right? Whether it increases some countries' GDP or not, as a community, and I would say as a community of international law practitioners, we should encourage that. And I would also say that does the ISD encourage investments or not is such a oversimplification. Of course, you can have significant investment flowing even without a ISD system. What type of investment? On which sectors? Under which terms? Will those investors without recourse to a neutral forum, will they seek to recover the same investment at the same pace, on the same basis, respecting the same rules? I don't think so. And that's something also that we need to keep in mind. And I think just to maybe plant the seed for the next topics, I would say that to connect these expectations with the reforms and the intended changes that many players seek, I would say that ultimately they are against, at the heart of the issue, it's the notion that they're against the fact that a sovereign conduct can be judged by a neutral panel. And I think that, again, that's a shame.
Thank you. Well, I think my co-panelists have covered a lot of the ground, and I just want to add, Sylvia talked about what states might be able to expect from ISDS, Investor State Dispute Settlement System, and Lucinda talked about how there really is no counterfactual. We can't say whether or not investment would have been higher or lower, because this timeline only exists once, at least as far as I understand. There's only one timeline. And but what I can say is, when I was at the Department of Commerce, I talked a lot to American businesses. American businesses were our main constituency. And I will say, when they were looking to invest in other countries, they brought up a lot whether or not there was investor protections under investment treaty, whether or not there was rule of law in the country. Now that goes beyond, of course, whether or not there's an investment treaty or not. But ultimately what the investors were looking for is predictability, stability. Professor Yannick talked about the importance of stability, and that's also a benefit that's conferred on the state as well. I think we'll be moving into some of the issues that people have discussed, the community has been discussing about reform and changes to the system. And I think one just point I'd like to make in terms of whether or not ISDS is living up to the expectations, what are the reasonable expectations, is that ISDS isn't a static system. As we've seen, countries are signing new international investment agreements. That's changing the substance of the substantive law. There are reform efforts at ICSID, big changes. There's the Institutional Working Group 3 that's looking at a lot of procedural reforms. ISDS isn't this, as much as some commentators would like to say, it's not this static boogeyman that is just out there and we can attack it. We can certainly talk about what features need to be fixed, and that can be connected to what our reasonable expectations are. But I think it might be a good segue here to just, we'll be talking about architectural change and procedural changes. And, those are the things that, may help to achieve some of the fulfillment of expectations that people have for the system.
We're going to move to one of the issues that's very controversial, and it's the whole question of, do these agreements constrain regulatory powers? Do they stop states from regulating, especially regulating in the public interest, for example, health, environment, social measures? And does the fear of being sued cause states not to take measures that they should otherwise take because that's their job? So Yannick, what are your thoughts on that?
Thank you. Well, I think as a preliminary remark, we can start from the rule of law. The very idea of the system is to place limits on the exercise by states of their normative prerogatives. That's the starting point. Then the question whether investor state arbitration constrains the regulatory power of states to protect public interest? Well, my answer would be that if you look at the case law as a whole, I insist on this, as a whole, no. And I think that the Philip Morris versus Uruguay case that we discussed earlier, Meg, is a very good example of what I see as the mainstream approach of arbitral tribunals as regards measures aiming to protect public interest. It remains that there is this perception, this urban myth, I don't know, you can call it however you want to, that ISDS has a chilling effect. So why is there such a perception? Well, I think that here, as with many issues that we will be discussing in this panel, you have to combine dispute settlement with substantive law. And I think that maybe one of the main reasons why there is this perception that the system creates a chilling effect is due to the lack of clarity, the vagueness of treaty provisions, obviously, the FET or the indirect expropriation. And I think that this is this uncertainty that exists for states, but also I insist on that for investors, because at the end of the day, the states are not the only ones to suffer, so to speak, of such an uncertainty. I think this is this uncertainty which creates that perception. So in this respect, I think that the best way to fix this issue and to make people realize that the system is not, doesn't have such a chilling effect, is not to replace ISDS, but this is to provide clarity, greater clarity in international investment agreements. So there is much to be said about the different strategies which are used by states to provide clarity, providing greater details. Well, I'm not sure that adding words necessarily adds clarity. There is another strategy which is referring to customary international law. I doubt that referring to customary international law really solve the issue of clarity. But there is another issue, and I think this one is quite fundamental as regards this issue that we are discussing now, is that the approach which has been adopted by some states leads the discussion from the constraints on the regulatory power of states to a discussion which pertains to gaps in the protection of foreign investors and investments. And here, for instance, I think of the approach of Brazil. So we discussed earlier, it's treaty practice, but excluding indirect expropriation from the scope of the protection granted by the treaty create kind of a gapping loophole, to use the terms of the tribunal in Pope and Talbot, in the protection of foreign investors. Likewise, the approach adopted by India in its BIT model, which provides that all bona fide regulatory measures, irrespective of their impact on the investment, shall not be considered as an indirect expropriation, creates quite a gap in the protection. So I think this this perception that the system has a chilling effect should not lead policymakers to another extreme, which is not a myth, which is a textual reality, by greatly limiting or excluding the protection which has traditionally been offered to investors. And as you said, requiring compensation for a measure which has an effect equivalent to an expropriation is not a big thing. So I will stop here.
I'd like to ask you a question. One of the biggest examples where we hear talk about regulatory chill and power in climate change. So often, like on the legal level, investor state and investor agreements are facing climate change.
So we wanted to bring in the issue on this concept of regulatory chill, how it overlaps with the climate change mitigation and climate change mitigation. And if you accept the assumption, which I think is by no means proven from a evidentiary point of view. Although I do have to say that I did do a little bit of research, and I've been following some of the regulatory chill research. And there've been a number of papers by Berg and Berger over the last few years. I think 2021 was the last one. And they've made the distinction that between two different sets of regulatory environments, what they call low capacity states and high capacity states, which, countries like, I guess, Mexico and the US and Canada would be high capacity states, lots of regulation. And then, other states have less regulation when they're dealing with foreign investment. And the statistical analysis of the cases show that in the high capacity states, there is, at least in the immediate year or two after a case being launched, some level of adjustment to regulatory policy. Some would call that a chilling effect, but at least a reaction, you could call it. In the low capacity states, there seems to be a heating effect. In fact, more regulation occurs, not less regulation. And I think that's probably a reaction to the, oh, we need to regulate this. They're suing us over something we've done. We're not, we don't have enough laws and regulations on this, so we're going to pass some more. And so you see kind of two different reactions in the kind of chill, this whole regulatory chill debate, which I think now when you bring that out into the climate change scenario, obviously climate change is something that's going to affect, every single country in the world. And I think it's assumed that private investment is going to be required, that this isn't something that governments can carry. And I think this goes to some of the themes that we've developed in this panel and some of the previous panels, which is, the idea that there has to be some form of dispute resolution. There has to be some form of rule of law covering these transactions and this type of economic activity. And whether you follow a Brazil model or an international system like ISDS, something has to be in place. It can't be a scenario where private equity and private investments are made because they'll be massive over the next 20, 30, 50 years, and believe that all of the risk of making those investments would be on the investors. It's just not a realistic assumption. So I think something is going to have to be in place. And we have a robust ISDS system in place. Perhaps it needs some tweaking. Perhaps it needs further discussion. I think that's not something that anybody's against. But to suggest, which I think after the recent COP conference in Egypt, there was a paper put out by a number of NGOs suggesting that there should be just no dispute resolution. I don't think that's a reasonable way of coming at this issue.
Of course, just a brief comment maybe on especially on the climate change aspect of it. I would answer maybe with just mentioning two countries, Spain and Mexico. If we can sit here and speculate as to potential cases of non-renewable companies suing because there are incentives given to renewable companies, but actually that's not the case law that we see out there. Those are not the facts that are being disputed. The facts that we see disputed more and more in more jurisdictions are the cases against Spain. You give a certain incentive or series of incentives for investors to take a risk in cutting edge technology so that you can meet very ambitious renewable goals. And then you remove those sometimes even before the plant started operating. So let's talk about reality first, and then we can speculate about other things. And I mentioned Mexico, not because it is in the same situation that Spain is in terms of cases that have been already filed, but I would point, and I'm sure it's not lost in this audience, especially to all the measures that the government of Mexico has taken against private investment in the renewable sector. And if you look at the statistics on the energy matrix in Mexico, the component of renewable has dropped significantly. Whether that will turn into cases or not is of course yet to be seen. But again, I think that the rhetoric against the dispute resolution mechanism as something that could affect negatively climate change measures to prevent it from happening, just digresses from reality, I would say.
Just two comments. One is, I think there's a critique that comes particularly from the environmental movement that ISDS may privilege foreign investors over domestic investors. And there is an answer to that. I'm not sure it's an answer that satisfies those critics, but I do think with respect to climate change in particular, it's interesting to think about how much traditional or his current industry is going to push back in the domestic context. I mean, in the United States, certainly we're going to have a lot of domestic legislation over climate change measures, and I suspect in the EU as well, because there are entrenched interests. So it's a more nuanced question, it seems to me, because the only challenges aren't going to be in the ISDS arena, they're going to be domestic as well. So how do these play out relatively? I guess the other thing I'd say is again, thinking about the critics, yes, indirect expropriation, Yannick, is one of the bugaboos for sure. But I think the biggest one is fair and equitable treatment. And there, I think there's actually not good understanding on the part of some of the critics of what it means, but it's exacerbated by the fact that the language of treaties is so broad, and it allows them to imagine all sorts of subjectivity and lack of standards being imported into the concept. So I come back always to the fact that states are the masters of treaties. And if they want to improve the treaties and bring clarity, and sometimes I think language does bring greater clarity to the standards. And certainly you see in the NAFTA whether or not you agree with what the Free Trade Commission has done in its interpretation, they have tightened that up. And it's open to states always to do that.
And then one last issue in this section, Dawn, has ISDS adapted to the diversity of stakeholders? This is another question people ask.
Yeah. And again, if we're talking about has ISDS adapted to the diversity of stakeholders, and have we reached where we need to be? I think the simple answer just has to be no. We are still in a situation where less than 25% of arbitrators are women. The change in terms of how many women are being appointed is still very slow. Progress is extremely slow. There are both glass half full and glass half empty. So, more optimistic and more pessimistic ways of looking at it. Of course, the numbers are increasing. You see women leading arbitral institutions. Not only do we have Meg Kinnear, but also Claudia Salomon, the first woman president of the ICC. You have Qian Bao, who was the Secretary General of the Hong Kong International Arbitration Center. There are women who are taking up important positions. Women are increasingly on arbitral panels, but the annual change in the percentage, the proportion of women on arbitral panels is 1 to 2%. And we have to ask ourselves, are we satisfied with that incremental of change? Even if you accept that change has to be incremental, and there's obviously plenty of people who would say that we must have much more radical change given where we are. But that by any measure has to be seen as slow. Similarly, if we look at diversity in the context of new entrants, in 2021, 1/3 of appointments, arbitrator appointments, were repeat appointments. So a good way, or an optimistic way of looking at it, is that 2/3 were new. But if you look at the gender proportion of who were those new entrants, 2/3 of those new entrants were men. So in terms of the a lot of people complain about the pipeline. There's no pipeline of women. And obviously that's not true. There's like plenty of smart women up here and in the audience as well. But the pipeline is actually growing still for men at a higher rate than for women. So again, that's I think it's important to look at the pessimistic side of things in order to lead the system to change. There's been a number of efforts that are really that can contribute to optimism here when we're talking about diversity. Arbitral Women is one. There's the Equal Representation Arbitration Pledge that a lot of us have taken. There's the new Equal Representation in Experts in terms of getting more diversity in the experts that are testifying. There's also REAL for racial and ethnic equality in arbitration. So all of these efforts are very important. The other thing that tribunals are doing, or sorry, that arbitral institutions and what we're doing is that we're measuring, right? So Meg talked this morning about the increase in women arbitrators. I gave some statistics. You know, there's that old adage about if you want to improve something, you have to measure it. So we have to know where we are in order to improve where we go, right? How are we going to know if we have more women arbitrators if we're not even going to, if we don't measure it? So all this measuring is good. And the other thing that another effort that's happening is a lot more of this intelligence gathering, right? So not only expanding the pipeline, but also showing that the pipeline actually exists and that there are competent women and capable women to lead arbitral tribunals. So we have the Compendium of Unicorns, which is this global guide to women arbitrators. There's the ICA report on the cross-institutional task force on gender diversity and arbitral appointments. All of these things are very important. But if I could just one last thing. So the last pessimistic point that I want to leave with, if I could be a pessimist for a minute, is that what Professor Catherine Rogers talks about the diversity paradox, right? So all of us might agree that, yes, we need more women on arbitral panels. We're very concerned about the lack of diversity. We need to bring more diversity into the system, you know, on the gender perspective, on new entrants, racial equality. But what that's not equating into is progress and actual change. And I want to leave on this particular topic. I want to leave with the importance of not just women-led efforts, because you know, Arbitral Woman is a woman-led effort. This Compendium of Unicorn, also a woman-led effort, the equal representation in arbitration. But men are also very important in advancing equality in arbitration. The previous president of the ICC, Alexi Moore, did a lot for this, and he got gender parity on the ICC in terms of the vice presidents. He did a lot of initiatives. That's very important to have champions, both men and women. And we also, you know, Meg talked about party appointments and how that's the place where we're really lacking the most in terms of progress. And I think there, what I would like to challenge all of you, all of us as members of this, you know, contributors to the ISDS system, is that you probably heard a lot about implicit bias. All of us have implicit bias. And it doesn't help to have better intelligence, more information, a bigger pipeline of women, if people continue to make decisions based on sort of unfettered and unchallenged implicit bias. And so I challenge everybody here to think about how not just voicing concerns about diversity, but also how in your own law firm, for example, or in organizing a conference or whatever it is. I mean, you know, Lucinda and Sylvia and I am sure we're still in the vast majority in our law firms in terms of women partners. I'm sure the women in the audience who have been parts of hearings have had the experience where, you know, they have the women's bathroom all to themselves because they are one of the only women in the room. And that includes witnesses, experts, tribunal members. You know, it's you and maybe the transcriber and the interpreters, and so I want to challenge all of us to really be thinking about, in organizing panels, having parity. And the last thing I want to say on this is just in terms of when we might be able to have this, when we might be able to be satisfied in terms of gender parity. Meg talked about, we finally have had some women-only panels. I want to quote one of my heroines, which is the late Justice Ruth Bader Ginsburg. She was asked about when we would reach, when she would be satisfied with progress in terms of gender diversity on the Supreme Court. And her answer was when there are 9. There are 9 justices on the Supreme Court. And I'm not saying that every single tribunal needs to be all women, but we have had all men tribunals for quite a long time. And having more diversity in that sense, and having panels that are, panels like this, speaking panels that are all women, it would help to reverse some of that balance.
Let's move on to the next bucket of topics, which is architectural change. And we're going to talk about a number of proposals that are out there and being discussed. And the first one, Yannick, that I'll give you is the whole proposal of a multilateral investment court, which would be both tribunal level and appeal, or an appellate body for investment arbitration. And Yannick, what are your thoughts on the viability of this, the advisability of this? What are your thoughts?
Much to be said. So I would like to look at it from 2 perspectives, 2 criticisms which have been formulated against ISDS, meaning the lack of legitimacy and the lack of coherence. So what can a multilateral investment court or an appellate body, how can it fix this? Well, starting with legitimacy. I think here, first of all, what's the problem, the perceived problem with investor-state arbitration? So the perceived problem is that the public interest, which is often at the core of investor-state disputes, for many across local populations, those disputes shall not be settled by an arbitration tribunal. There is a perceived, there is a perception that there is a lack of compatibility between this public interest dimension and arbitration. Well, it is often said that this incompatibility is due to the specific features of arbitration, in particular the fact that the arbitrators are appointed by the parties. Well, to be more precise, for those critics, the issue is not so much that the state appoints an arbitrator. The problem is that the investor appoints an arbitrator. Well, I think that the specific features of arbitration is not the only and maybe not the main reason why there is a lack of acceptance across local populations as for ISDS. I think that those specific features are kind of the tree which are hiding the forest. And what is the forest? The forest is the international nature of ISDS. And this criticism boils down to this. Local populations increasingly do not accept that an international tribunal interfere within in domestic affairs. And this criticism, if you look at, for instance, the public consultation which was organized by the EU in the TTIP context, it's pretty clear what the people want mainly is simply those disputes to be settled not by a multilateral court, not by any international tribunal, but by a domestic tribunal. And so this critique, you find it formulated, for instance, in Europe against the European Court of Human Rights. And in France, in the UK, for years, there have been criticism. People have been saying, what's the legitimacy of this international court to address issues that they see as being purely internal matters? So if I'm correct, I'm pretty pessimistic in the sense that a multilateral investment court or an appellate body are not better equipped to address this concern. There will be international tribunals. So in this respect, and to link this to what I've said earlier, I think that we should be, policymakers should be really, really cautious, not again to support urban legend, because this again provides credibility to unfounded criticism, and this weakens a system which again has been pretty successful in the past decades. Moving on to coherence, I must say I'm not again very optimistic about the possibility of a multilateral investment court or a multilateral appellate body to address the issue of coherence. Why? For a simple reason. There is a mismatch between the multilateral dimension of a court, of an appellate body, and the bilateral dimension of mainstream treaty practice. So yes, an appellate body, a multilateral investment court, would provide coherence in the interpretation of each international investment agreement. It also likely that an appellate body or a multilateral investment court would have a tendency to interpret in a similar manner different treaties, different treaty provision that they considered as being sufficiently similar. But I think there is a risk here, sufficiently similar. What does it mean? To what extent can we consider that there is sufficient similarity? And here, I'm afraid that a multilateral investment court and an appellate body may deny the specifics of each treaty, may deny the fact that Article 31 of the Vienna Convention on the Law of Treaties is a general rule of interpretation, which all calls upon tribunals not only to focus on the text of a treaty, but also on the context. So the text of the two different treaties may look sufficiently similar, but then if you focus in particular on the context, then they may not look that similar. So that's a risk, I think, that a multilateral investment court and appellate body could face. I will stop here.
Thank you. Lucinda is going to talk a bit about the USMCA and the interesting difference here where you have one country that's not offering investor state, Canada, and one country that is, Mexico. And I guess the United States is the pivot point in the middle.
Thank you, Meg. Well, let me just say, if I may comment for a moment on Yannick. We started out talking about ISDS as a system, but as others have said, it's not really a system in a way. I mean, ICSID is an institution with a set of instruments around it, but I think, Yannick, your point about the number of treaties and the diversity of treaties is really an important one to keep in mind as we talk about this, because there's a lot of instruments, but how much are we really dealing with the system is the question I'd put on the table. So I'm not going to say a lot about USMCA, USMACA, however you pronounce it, which is a subject of much debate, partly because I know that we're going to have a whole panel on this tomorrow and talk about it in detail, and it's late, and partly because I'm looking at this audience and knowing that most of you know as much about this as any human beings on the planet. So I'm going to be very modest in what I say. But it is an oddity for sure to have this kind of half and half approach. And I go back to some context. I believe in context. I think all of us who do international law have to believe in context as important. But if we go back to NAFTA, when the NAFTA Chapter 11 was negotiated, I think if you talk to the negotiators, there wasn't an expectation that it would produce the mix of cases that it did. Nobody probably, Meg, would have guessed that Canada would be leading the charge, if my count is right, in terms of numbers of cases at the end of the day. And so it's an important illustration of how wrong we can be about the kinds of issues that may arise and the need for a mechanism. And of course, in the United States, which is my country and has never technically lost a NAFTA Chapter 11 case, although it got lucky let's just say, with one of them in particular. And the jury is still out because we're still in the legacy period. So it could still happen that before this chapter closes, the United States will lose something. But we know that there was and is still a real political backlash against ISDS for a lot of the urban myths that Meg has talked about earlier and more, subversion of democracy, and I think a fundamental misunderstanding in some respects of the system. But I'm very nervous actually about carving the US out in terms of the treatment that will arise, and particularly from an international perspective, how US courts, if they are the ones to be confronted with these issues in the wake of the demise of the NAFTA and any ISDS mechanism, how US courts are going to deal with these issues. I mean, we have some strong courts. I don't mean to impugn the US courts, but I'm involved in a case right now where a treaty between the US and Canada is at issue, and the federal judge in that litigation says, oh, this treaty is above my pay grade. It's a pretty straightforward treaty, actually, but I think we know in the US that US judges are just not that well equipped to deal with issues of international law. So I'm concerned about what this phase is going to mean for the treatment of US investors. Mexico, of course, I think we'll hear in detail tomorrow about what the provisions of USMCA will bring, and it's a very interesting issue to set of things to think about what they're targeting here. The return to some degree of exhaustion of remedies, which I find really interesting, but it's not total exhaustion. It's just you got to make a certain effort to exhaust. I find that really interesting. So I think we're in an experimentation period. The US loses out. Canada and Mexico luckily have the CPTPP. So they still have remedies that we from the US will not have. But I think it's inevitable that we go through this period of rejection and experimentation. And if the arc of history bends in a certain way, I hope it will bend over the long run to more rational thinking about dispute resolution.
Thank you. Another model that people talk about is state to state, and you heard our colleague from Brazil talking about the particular approach that Brazil has been taking. We've heard discussion about potentially a priority for state to state in the African Continental Free Trade Agreement. So this is a theme that comes back, which I think is kind of interesting given all of the difficulties of getting states to actually take on investment cases from the early days that started this whole investor state process. So Ian, I wanted to ask you if you thought that state to state is going to come back as the priority forum, or if it's going to have a greater role in the future.
Yeah, that was a really interesting discussion we had in the previous panel. And Mateus went through the Brazil experience, and I as well kind of went digging for cases and couldn't find any. And I think part of that is that of the various treaties that Brazil has signed, they actually haven't ratified most of them. I think they ratified the one with Mexico and one with Angola, and those are 2015 treaties. But there's been no cases, and there seems to be no rush to ratify the balance of those treaties that were negotiated in that previous government. I think just a couple observations on the state-to-state option. Almost all bits have a state-to-state option. Free trade agreements have that option. Actually, the new USMCA, or as Canadians like to call it, CUSMA. Come on, got to have your, in the right order. But under CUSMA, in fact, that's going back to a state-to-state as between Canada and the US. It's not that there's no investor state, it's just not, there's no protections, there's just no investor claims as between Canada and the US. I think when you look at the state-to-state option, that's certainly, something that's been around for a long time. It's the original nature of international disputes or state to state, and that's the model. I think that the rejection of that model was the reason ICSID came into being. We had a number of ICJ cases, like Barcelona Traction was a good example. That case went on for, I don't know, 10, 15 years, maybe longer. It was over a power plant that was effectively expropriated in the late 1940s, and it wasn't resolved, I think, till 1972. So, and that was just a power plant in Spain. I think the lessons taken from that were that there must be a more efficient way of doing this than reverting to the PCIJ or the ICJ to resolve these types of disputes. So really, it's kind of a back to the future scenario here. It's absolutely an option, but I think experience is told, and the reason, absolutely ICSID and UNCITRAL came into being was to provide a solution that wasn't a state-to-state mechanism that met some of those objectives that Meg talked about this morning. Providing an independent dispute resolution mechanism, allowing claimants to bring cases and not have to go through the political and diplomatic barriers, which are substantial. And at the end of the day, because of those diplomatic interactions between states, the reason for the cases would get lost in a diplomatic interaction. And it wouldn't be focused ultimately on some of these disputes. So there was all sorts of good reasons in the 1960s to bring around ICSID. We're now kind of revisiting that, and we've seen some examples of that, Brazil being the most prominent of those examples.
Sylvia, I want to move to you, and in particular, I think we'll recall that when Bolivia, Ecuador, and Venezuela left the ICSID convention, there were also a series of negotiations to actually start what I saw as almost an equivalent to ICSID, but on a Latin American basis. So there have been discussions on a Latin American basis about architecture, and I want to know your thoughts on this.
Thank you. So that's right. I think that in the prior panel, there was this theme of how special we are in Latin America, or we're not. Let's see what you conclude on the basis of this. But I think that that period of time in the late, from like 2007 onwards, there was this time, and here I see a young crowd who may have not witnessed it, but many of us did, which was that Bolivia, Venezuela, and Ecuador, they were at the forefront of these breaking from the system, right? And Argentina made an express decision, and they would announce it like that, to stay within the system, but just fight really hard within the system in the sense of their defense and their strategy there. But these other states decided to form an alliance, which was called ALBA, and to create a court, right, that was separated from these other mechanisms out there and existing conventions and so on, and come up with their own investment protection, or I would say investment court. As you can tell today, that did not work. And it did not work because I'm sure for political reasons in terms of them coordinating and coming up with a plan, but also it would not have worked in the sense that the issue is, again, having a neutral forum to bring those claims before, right? And having an express agenda not to be sued, right? And not to be, in any case, have cases against you is not, I would say, a very compelling offer to investors out there. So what ended up happening actually is interesting, because it give us a sense of what may, what we may see at a regional level, whether it's in Europe or in other regions that may decide to change the system and do away with the arbitration system as we know it. And that is that those states concluded commercial arbitration clauses with investors, only with those investors who had the bargaining power to negotiate those arbitration clauses. So those who know me know that I love to point to ironies. I find a lot of things to say about the notion that you advocate transparency, and yet you go back to ICC and ICC clause with CETAN, Santiago or UNCITRAL, with the system in Santiago, and within those cases, you refuse to make them public. I think that there's some tension there, I would say. And the other point that I want to bring, and it has to do with this potential contractualization, right, or privatization of the dispute resolution mechanism, is not only that it's going back in time, which of course we can do if it's for better, but we shouldn't if it's not, is the fact that those smaller companies, those perhaps companies that have one project, will be left probably with no protection. And there was a question before in terms of the diversity of stakeholders. I think the one diversity in that sense is smaller companies versus big companies. And I think that it's a pity that going back again to that scenario will make the not level the playing field. And I would also say that in terms of that, the point of having more transparency and also encouraging states to behave accordingly, that's also, there's a lot lost too if you just keep that system as a commercial arbitration as opposed to one like the ones that we are used to. And now just one more thought before I conclude these remarks, and that is that what you also see is that, as it was the case back in the 1980s in Africa in the oil and gas sector, where you had an exit clause and the applicable law was the local law and international law. What we are seeing now too is that for those major projects where there's a negotiation at a very difficult level and a very high level, there is some instances in which Latin American states are agreeing to arbitration clauses like ICSID and others, and providing a mini bilateral investment treaty in the contract, right, which contains provisions on fair and equitable treatment, expropriation standards, and so on. Do I think that that's bad? I think it's better than nothing for all parties involved. But at the same time, I think that there's a more commendable, again, results that, again, we as professionals in this field, we should push for, which is for not just those specific companies to have access to that, but for that to be available to other smaller companies with less bargaining power as well.
And Don, we're going to let you finish the architectural portion on that irony, which is we talk about architectural change, changing how we do ISDS, but nobody's been willing to really look at the substantive obligations. And that probably to a lot of people seems to be, if there are discontents, aren't they, with the substantive obligations? And why have we been timid about having a good hard look at those?
Yeah, and I think what I would say to that is that we have to remember that, like Yannick said, and as Lucinda also said, the whole system, to the system of ISDS, to the extent that it's a system, it's a decentralized system. That is the substantive law here that we're talking about is made up of mostly bilateral treaties. There are a number of multilateral treaties that are coming into being, but by and large, it still is a bilateral system where two countries are having negotiations, and then they sign a treaty that they both agree to. We have seen reform of substantive obligations. I think a question that is, from the critics that would say, why have architectural reform without substantive reform? I would just say that there is actually substantive reform happening, maybe not in the way that they would like, but USMCA is an example. USMCA is different from NAFTA. Lucinda and I have probably, made a decent amount of money advising clients about those differences. And the interesting thing is, while there may be some convergence in terms of how people are looking at something like fair and equitable treatment, I think there's a pretty good convergence on expropriation, but you still see differences, right? So If you look at a couple of examples of substantive law reform. So in the European Union, you have the modernized ECT, Energy Charter Treaty, where they so far hasn't gone anywhere, but they're looking at revising substantive obligations. And if you just take the example for example, of dual nationality, which is a pretty hotly contested topic, but in that treaty, in that sort of substantive reform effort, at least where it was, last I saw, they wanted to exclude dual nationals from suing one of their own host states. So that's a particular view being maybe even agreed upon by a particular region. But then again, you look at other treaties, and other treaties have come to a different conclusion where they say dual nationals are fine, but we want to look at the dominant effective nationality test and look at which state is dominant. So we're not, I think it's difficult to say having some sort of substantive reform. It sort of assumes that you could get everybody, for example, the UN, and say, all right, let's have a resolution on fair and equitable treatment, and let's all agree on it. I'll just say it's never going to happen, or at least I wouldn't put my money on it, right? And you do have, even within treaties, so Lucinda said, within NAFTA, for example, the parties did decide to basically revise what they meant about fair and equitable treatment, because they were a little bit unhappy with how it was being, how that clause was being interpreted by tribunals. So there are these mechanisms for substantive reform. It is happening, maybe not in to the degree that some would like, but it is happening.
So this is a very interesting discussion, and I hope it's interesting for you as well, but a couple of things that haven't come up that occur to me. One is, and I'm thinking of now the NAFTA when I talk about this, but also some of the other free trade agreements with investment chapters, that, you know, the off ramps or the on ramps that are in some of these treaties. I'm thinking of the pre-clearance in the NAFTA for tax measures, or the provisions relating to financial services measures. There have been efforts to create specific processes for certain kinds of issues that are thought, going back to the discussion about public policy and regulatory chill, ways to kind of manage those issues. But I don't think those have been invoked very much. So I don't see those as a big solution. The other thing is, but I just wanted to mention that because I think it would be interesting to look at those more horizontally. The other thing that comes to mind in this discussion, I think it was Luis Gonzalez who mentioned earlier the claims commissions. And you know, when you have 25 or whatever it is, Argentina cases arising out of an economic crisis, when a sovereign defaults on its debt, they bring all the creditors together and they try to negotiate out a resolution. They try to have a more systemic rather than a one-on-one solution. So I do think we need to get more creative about how to deal with these events that have broad-based effects. Of course, for places like Ukraine, we're going to end up with some sort of commission because that's just on a huge scale. But we do see recurrently in the international system these situations arise, usually economic, usually crises of some sort. And I think we need to think about how we deal with those situations in a way that's not just one-on-one, because there are so many common issues. I say this as the person who fought against consolidation in the sweetener cases that were referenced earlier. I still think that was the right outcome for those cases. Sorry, Hugo. I cutting against that, when you look at the Argentina experience, I think you come away saying there has to be a better way for situations like that.
Okay. May I just briefly chime in on that?
Go ahead.
A couple of things. First, thinking about, at least my experience on the ground, the vast majority of the cases where the real discussion it's on the facts. And I would argue, in terms of, putting all our hopes or all our energy into coming up with the best formulation or the best carve outs or the best, whatever it is that we want to accomplish. I would draw an analogy with the Constitution, right? Treaties do by definition have to have some open texture. That's inevitable. It comes with the territory, and I'm the first one to say it, maybe more articulate than I was. It was Aristotle quite a few years ago, right? You need to have, and you cannot foresee every single situation that is going to arise, and you need to be able to have that argument. And I think that honestly, sure, there are some jurisdictional issues, there are some conceptual framework issues that we argue strongly one way or the other, but from the battlefield, I would say the report is, and I don't know if other practitioners would agree, it's a lot has to do with the facts. And I think that may be lost in a court system, which the agenda of which would be to just be focused on a given dogmatic approach for, I would say, political reasons, or an agenda that is other than the specific case that they have in front of them in light of the specific evidence and the specific arguments that were made. And as to the suggestion of finding some sort of solution and sitting down at the table and try to solve those claims that are similar to some extent, I would make 2 points. One is that more than the regulatory chill, what I can, and again, of course, it's anecdotal because it's based on my own experience and opinion, but what I have seen and witnessed personally has been settlement chill. And I don't think that, going back to the prior panel, I don't think it has anything to do with the legal background. It has to do with the lack of incentives for public government officials to sign a settlement for PR reasons, for political reasons, for fear of being involved in some sort of accusation with no ground. And in the case of Argentina, while the context was the economic crisis, the real claims were the measures that were taken by the government with respect to certain contracts. So I think that, and certain regimes, right? So I think that it would have been a bit more challenging to do what they have done, states typically do with bondholders, for example, or it's a bit, I'm sure it's not simpler, but it's at least you're working from a more cohesive group of stakeholders.
Yeah, still on architectural change. Just on this, reforming the procedural aspects without reforming the substance. Well, taking into account that the starting point of the reform are all those criticisms across local populations, among them coherence and lack of legitimacy being key, it's kind of a nonsense to focus only on procedure, because as I said, you can have a multilateral investment court, which has bilateral instruments, you don't go too far, or you don't go far away at all. Legitimacy, if you still have the same provisions, whether they're applied by an investor state arbitration tribunal or by a multilateral investment court, will change nothing in the eyes of local population. So I think if really the purpose is to address the criticisms, the perceptions, the urban myths, there is really a need to combine, to have a holistic approach in the reform of international investment and arbitration. Second point, you say, Lucinda, that in a way it's an experimentation period. Well, in a way, haven't we experimented all this already? And we are back to what Meg said earlier, and you touched upon that. I mean, state-to-state arbitration, it's akin to diplomatic protection. We have tried this. And politicization, and that's why it was created. And this is why early 20s arbitration was introduced in contracts. So we have already tried that, domestic courts as well. So now we can see that we have longer exhaustion of local remedies period. We have, even in some treaties, we have full exhaustion of local remedies. We have experimented all this. And also, as for state-state arbitration, I think we are focused very much on the upstream, meaning the access of investors to dispute settlement. But I think here, as regards state-state arbitration, we also have to look downstream. And diplomatic protection is really insightful in this respect. If a state exercises diplomatic protection, if it endorses the claim of one of its nationals, then it becomes a state-state dispute. So let's say that they agree on the jurisdiction of a tribunal. Let's say that the host state is considered as being internationally responsible. Let's say that full reparation is compensation. The compensation is paid to whom? To the state. Has the state any obligation to transfer compensation to the investor? No. So I think that's another problem with state-state arbitration. It's not only the fact that investors have no access anymore to international adjudication, is that downstream compensation question mark.
We are coming close to the end of our time and we haven't gone through procedural change. So I'm going to take the moderator's privilege here and we're going to do this as sort of short snappers on procedural change because we really do want to make sure that the audience has a chance to offer their comments. So let's say in about a minute, just a quick thought, Lucinda, transparency.
I'm not sure what the question is. Of course, we're all in favor of it. Yes, transparency. But the questions are, why has there not been more uptake of the Mauritius Convention, the 2014 Convention on Transparency and Investor State with 9 states parties? At this point, it's pretty pathetic. Now, Meg mentioned this morning the ICSID rules, the new rules, and I think they tilt very substantially towards transparency. And let's face it, you can't have complete transparency in these kinds of disputes. I think we all recognize that there can be sensitive state information, sensitive investor information, but there is a public interest in these cases. That's undeniable. And the more we can tilt in the direction of transparency, the better. And I think we're going there. So that's good.
Sylvia, availability of arbitrators and timeliness of the process, where are we at?
Oh God, I'll try to stay as positive as Lucinda, but I am, because I think that that's within our control, right? In the sense of we can do something about it. We have the new rules, the ICSID rules that provide for the possibility of expedited rules. There's, I know for a fact that there's some investors that are trying to get states to consent on that. So I hope that that actually materializes. That would be a nice, consistent position when it comes to, again, justifying a reform, because proceedings take too long, as we have heard. And then in terms of arbitrators, I think that as that pool of arbitrators gets bigger, I think that I've experienced that arbitrators are tending to be more and more focused on a timely resolution of the dispute, of having the awards rendered as quickly as possible after the hearing. So I think that there's hope, and again, and I think that as you can tell by now, probably I do represent investors all the time, but I think that there's a lot that my colleagues on the other side representing respondent states can do to help improve those statistics and make more efficient and expedited proceedings for all of us.
Dawn, third-party funding.
So this can be really quick, because I think third-party funding is actually a place where we're seeing a nice convergence in the international community. I think the number one problem that most people identify with third-party funding is conflict of interest. And the way you solve conflict of interest, or at least the way that the community has solved conflict of interest, is disclosure. A lot of the arbitral institution rules talk about disclosure of act of third-party funding. A number of cases have come out to say also the same. And then, of course, ICSID rule changes to actually acknowledge third-party funding comes out the same, that there should be the disclosure of the fact of funding, not necessarily the terms of the funding. Now, of course, there's obviously people who disagree with this, but I do think that there is a nice convergence on third-party funding. I think that most recognize that third-party funding is important for some of these small investors that may not have access to justice otherwise, or investors whose entire investment was wiped out and every single penny they owned was wiped out. And so it's a little hard to pay for legal fees when the state has taken everything. And so third-party funding then ends up becoming a really important way of accessing the investment dispute settlements system. And I'll just one point, because there is, there are treaties, for example, the UAE Argentina treaty, which was just signed in 2018, so it still is fairly new. It does prohibit third-party funding, so it's not 100% convergence. There are still, sort of detractors and movements in other ways, but I do think there is a nice convergence.
Ian, mediation and fact finding, is it going to take hold?
So we've seen a lot of developments on the mediation front in the last year. As part of the ICSID reforms, there's a total revamp of the conciliation and the mediation, and there's a new set of rules on fact finding. And they really are innovative in the sense that they've caught up with the kind of modern practices in mediation. And they're really open to not just ICSID parties and those investors associated with ICSID parties. It's open up completely. So it's there available for mediation of any disputes that kind of vaguely are relate to investment. So it's something that's there. People need to look at them, get more comfortable with them. I think the big question though, about the use of mediation in investor state goes to similar point that Sylvia made about settlement chill. I think there's a mediation chill in the sense that you need decision makers to engage in a mediation, because mediations are consensual. Both parties have to want to be in the room. Whereas with strict ISDS or arbitration, one party can compel the other party to be in the room. And unless we have some sort of mandatory mediation, which is being discussed, and actually it was kind of kicked around in the working group 3 in the last session about, if we're really going to be serious about mediation, there has to be some mandatory element. I think that was rejected in those discussions. But we are seeing developments in the working group 3 at UNCITRAL. They're going to put before the commission this summer a new set of model rules and guidelines. So that's been I think a big positive movement forward at the UNCITRAL and ICSID level. And let's see if we can continue to move forward.
Yannick, are we going to start seeing states acting as claimants more often, not just respondents, but claimants?
So in a nutshell then. Well, here again, it's actually a combination of substantive law and procedure. You need states, you need investors to have obligations, in particular under international investment agreements, and you need procedural mechanisms. Well, if you look at recent treaty practice, well, the least to say is that states are very cautious. In particular, if you look at substantive obligations, very few treaties place obligations upon investors. And if you look at those treaties which place obligation, you're again very cautious. For instance, if you take the CSR provision, corporate social responsibility, very soft law language, should make efforts to voluntarily, just in case we didn't understand that it's soft law, so should and voluntarily. When it's hard law language, it's not obligation of result, it's best efforts obligation. So very, very cautious. Well, then we have to be fair. If we look at the broader picture, public international law, there is actually, if you take human rights to date, private multinational corporations, private persons have no human rights obligation. So in a way, international investment law is no different than public international law. But maybe to be a bit optimistic, I think that there are interesting strategies that you can see in recent treaty practice, in particular in the Morocco-Nigeria BIT. So obviously it hasn't entered into force, but it adopts approaches that states may want to use in the future to place obligations upon investors. Notably, very interestingly, they link investors' conduct to states' human rights, environmental, and labor obligations by providing that investors should not manage or operate their investment in a manner that circumvent those obligations that states have. So very nice way to contribute to the horizontalization of human rights in the public international.
Super. Does anyone in the audience have a question? Ricardo?
There hasn't been any really regulatory chill case in Mexico. If you come up in the history, even the one or the last, it's a governor that expropriates with a environmental pretext a land. It is someone that wants to get advantage of a tax exemption. It's someone that wants to take advantage of the sugar regulatory Mexican framework. So at the end, if you look at the Mexican side, there has not been really a regulatory chill, and I leave aside the current electricity thing. And the other comment I wanted to make is this issue about coherence and substantive reform. At the end, you cannot use an appellate body, and we will discuss this tomorrow, but you cannot use an appellate body for coherence if you want to be loyal to the Vienna Convention. Because at the end, if you want to be loyal to the Vienna Convention, you have to look at the text. And those texts, those millions of texts are very different. And you want to be, if you want to be loyal. So maybe the approach, and I'm not suggesting this, I'm just saying, is to change the method of interpretation and leave aside the Vienna Convention. And this ties, well, this ties back to the issue of substantive reform, because at the end, and I don't know your views, and maybe that's my question, tribunals have come closer and closer to interpreting provisions, talking about FET, talking about measures tantamount to expropriation. So at the end, do we really need substantive reform? And that substantive reform has to be connected somehow to the way you interpret the provisions.
Any comments from
Let
the?
me bring it forward.
So Bart Legeman, I was just going to ask a follow-up to Yannick's remarks. If you have obligations on an investor with respect to tax laws or environmental laws or whatever, in a treaty that also has consent to ICSID arbitration, doesn't that have the perverse effect of depriving the state of its ability to enforce in its own courts its own laws with respect to environmental laws? Because you have a consent to ICSID arbitration, which is exclusive of all other remedies, and the state has agreed to go to ICSID arbitration over disputes about environmental laws.
I wanted to follow up on the initial question about, the comments that were made in terms of the empirical evidence and what purpose, or if international investment agreements serve a purpose in terms of promotion, attracting investment. I've always wondered whether, the focus is completely off. And just to give an example, if you look, for instance, at the Mexico-Kuwait bilateral investment treaty, and you study it, assiduously, you're bound to find that no, BITs do not serve, they don't attract investment. The investment was very little, continues to be very little, if any at all. If you look at the NAFTA on the other end, you may, to use Ian's words, you may find that it's inconclusive. Of course, investment skyrocketed, but the NAFTA was not about ISDS, it was not about Chapter 11. The NAFTA, as far as Mexico was concerned, was not even about trade and investment. It was a component of a much broader policy that, again, another topic that you all referred to was to give Mexico long-term consistency and stability. And it served that purpose. And if you compare Mexico with a fair number of free trade agreements and bilateral investment treaties to Brazil with none, and you look at Brazil's, we saw the statistics today, the third recipient in the world for investment flows with no investments treaty. So, how do you change the focus in order to sort of figure out what role do investment agreements play in this much broader context? And going back to Mexico's view of providing long-term stability, what happens and what role do those treaties play when those rules are changed for good or bad reasons?
I think there was one more question, but I'm going to suggest, Ricardo, for your next Mexico International Arbitration Day, that just the whole piece about does investment increase because you have investors' data and investment agreements is something, there's huge amount of things we could say. So one last question, because I know people have had a long day. Go ahead.
I guess I'm standing between y'all and your drinks, so
Very
I'm sorry.
brave.
There were two things touched upon that I think are very interesting. First, diversity, and second, the mediation chill that was talked about by Ian and Sylvia. On the diversity side, Don, do you think that it is more a matter of the pipeline and competency of people in the pipeline that is preventing more women to be appointed as arbitrators in cases? And related to the mediation chill, we know that states are not going to mediate and are not going to settle because the responsible parties on those states, the administrators, may be held liable, may be held criminally responsible. So how do we solve that problem? Do we put in the treaty a provision that says if, I don't know, the Ministry of Economy agrees to settle a case, he's not going to be held responsible and held, criminally liable for having settled? And talking about pathetic numbers on conventions, the Singapore Convention on Mediation has maybe 20 countries as of today having signed it.
It's about 55 or 60 now.
Oh, thank you.
Getting there.
Thank you. But this is still very low considering that is a convention that would allow for the international enforcement of mediation agreements. So what are your thoughts on those?
Okay, why don't I leave the panelists to pick whatever answer they want to address? And then I think we better close the proceedings and thank our panel. So quickly, anybody who wants to address any of these points? Lucinda, why don't you
Well,
start?
I'll jump in. So I'll just say on the chill issue, I was on the ICSID panel of conciliators for 6 years, appointed by the United States. And guess how many cases? Big zero. I mean, it's a real issue. And I think we need, I don't think the right answer is to give a blanket exemption to an official, but maybe to try to devise processes that will help within governments protect that official, because I think we really do want to encourage negotiated resolutions. So the only other thing I would say, Bart, I'm not sure I understood your question, but I think I've been looking a lot at the legality cases, which in 2/3 of investment treaties have some form of legality clause in them that says that the investment has to be made typically in accordance with host state law. I mean, there are multiple formulations. Those issues go to consent. If you have, but if you have standards of conduct for investors that apply during the operation of an investment, it's not clear to me that they would function jurisdictionally in the same way that a legality clause that's tied into consent. They may affect damages, depending on the investor's conduct. They may affect the merits. I suppose in some circumstances, they could affect admissibility, but I'm not sure I understood your question, but I don't think it's wrong to start thinking about standards of conduct for investors during the life of the investment. I do think we have to look at the jurisdictional issues that have come in, because I think those are creating a lot of perverse incentives for states, and you see those in multiple areas, the corruption area for sure, but others, they're growing. I mean, the number of legality cases is just astonishing. And we could talk for hours about it, but I'll stop there.
So just on the pipeline issue, 2 points. One is that there are plenty of intelligent, smart women with the experience of being counsel, of being arbitrator, but a lot of times, if you think about lists that have been proposed for president, for example, or lists that you propose to clients, I'm not saying you, but just us generally, right? How many times has that been almost all men, or completely all men? Or how many times has there been one token woman or two token women? So, and that relates to the pipeline. So my first answer would say no, because there are, I mean, Lucinda is a great example of as somebody who is an arbitrator, and there's many more women like her. But where the pipeline issue, I think, comes into play is that if you consider that 50% of law school students, generally speaking these days, are women, 50% of associates, generally speaking, at big law firms are women, but then you look at the partnership of women, you look at the speaking roles, who's speaking in a hearing, even if there are women sitting in the room, are they backbenching? Are they just, first chairing, second chairing? Are they actually getting to speak? All of that is important, because if women are not given leadership roles, if they're not being considered for those leadership roles or speaking roles, then you do end up having a pipeline issue. There's fewer, I wouldn't say there's zero, but there ends up being fewer, right? Because you're not giving those opportunities. And so I think that there's, two things we need to do is, one, we need to we need to be more aware of the women who already exist, but then also just knowing that isn't enough, right? We need to actually put women on lists for consideration for arbitrators, put women on lists for consideration for president, but then also thinking about your own teams, thinking about your wherever you are.
So I will not answer all the questions. I'm available during the drink. So to address a question which hasn't been addressed. So yeah, the fact that there is a risk for Article 31 and the fact that it's a general rule of interpretation, I agree. This is what I said. And also, in addition to the text, the object, the purpose, and the context, also very important, there is Article 31(3)(c), any relevant rule of international law, which is applicable in the relation between the parties, should be taken into account in the interpretation of the treaty. Whether we can get rid of that, I'm looking forward to your guidelines on how to interpret. About consistency, well, I'm not that sure that there is such a degree of consistency in arbitral practice. Look at the MFN. I mean, this whole issue about the application to the dispute settlement mechanism of IAS, this is not solved. Look at indirect expropriation between the approach adopted by the Metanex Tribunal and the one adopted, for instance, in Philip Morris versus Uruguay. It's quite a difference. If you look at more specific issues pertaining to the umbrella clause also, and yeah, I think there are still disagreements. But let's assume that there is such a consistency. What would be the added value of clarifying the content of the treaties? Well, to prevent departure from those mainstream interpretations. And I think that there is another value of clarifying the treaties. And to understand this, we need to get back to why we have a reform. We have a reform because local populations are unsatisfied and policymakers want to speak to their local populations. So even though clarifying doesn't have an important legal added value, it has a very important, I think, political added value in the sense that policymakers can say to their constituent, I heard you, I made something.
Thank you. Just a couple quick comments on this notion that treaties can be part of a broader, bigger picture. That was the case for the Latin American BATs as well, right? They were part of the Washington, or many, or the vast majority of them were part of the Washington Consensus Program, which again was spearheaded by the US, which now has sort of second thoughts about the whole idea. But anyway, so there's that perspective as well from the Latin American arbitration angle. And then maybe one comment on this last point of catering to local population. I wonder if the local population really has ever read a decision, understood the facts, and therefore formed an opinion. And I don't want to sound condescending. I remember, I think it was back in 2012, I came across this article in The Economist, and the headline was something like, secret courts for states. It was really over the top, and it was The Economist. Make me think of a few things. Oh my God, when I read the press, what is actually happening? Because if in the one field that I know what the reality is, or I think I know, I come across such a one-sided description. And then on the issue of obligations, investors' obligations, investors do have obligations, many obligations sometimes, and those obligations can be as stringent as they can be under the local law system, to your point. And I think it's a bit one-sided to think that there's nothing going on at the local level, right? At the local level, it is the state who's saying which obligations those are, right? In principle, and has its own fora to decide on that. And I think that one thought that I'd like to share with respect to bringing issues of like human rights violations or other or environmental issues is that I think that if we want to open the door, and I see, of course, the value in that, then the state also better show that they are complying with those standards themselves. And I say this because in a different context than a treaty that provides for that expressly, but the good old BATs that were short and didn't have any language to that effect. I've been in cases in which a state would, I would submit opportunistically saying, well, this investor had a water service company and water is a human rights, and therefore we could force them not to increase the tariffs and etc. And my reaction to that is, okay, let's look at the human rights of that population today. You had that, investor left the concession, you've been in charge of it for 10 years. What's going on with that local population? Of course, it was radio silence, right? And I discussed it with some arbitrators who signed, I know, especially one award that had a bit of an opening of that door, and I also got some silence. So again, if we are to open that door, I think again has some very positive aspects. We better make sure that we really caring about that and are consequential with that agenda, that intention.
So the question we started with was, where are we in solving problems of states, investors, and society?
Solve them all.
Well, I think it's done. I think it's all solved. This panel has answered all the questions. We can all have a drink now. So.
The door.